BTI 2014 vs. Sequana and others, 2022 UK Supreme Court. This case invoked the subjects of company law and insolvency law. Under company law it invoked the principle of director's duty, and under insolvency law it invoked the principle of clawback for illegal dividend distributions to shareholders. Only the most basic facts of this case were needed to be put across by the court. The basic facts were that AWA was a company who in 2009 gave out a €135 million dividend to their shareholder Sequana. There were 5 directors on the AWA board who did this. These 5 directors of AWA and their shareholder Sequana were the 6 listed defender-respondents in the case. In 2018 AWA went into insolvency with massive debts, and many third parties who were owed money by AWA did not get paid. BTI was the appointed liquidator who represented many of these third parties who AWA owed debts to when they went bust, and BTI took over AWA when they went into insolvency. BTI was therefore pursuer plaintiff in this case trying to get this €135 million dividend back, and the directors from AWA who gave this out to Sequana were the defender-respondents. BTI sought to argue that this distribution of €135 million by the directors to Sequana in 2009 was a breach of these directors' duty. BTI sought to argue that this distribution meant that AWA technically became insolvent, as they had a big pollution problem at that time, which they had to spend a lot of money on to fix in the 9 years after this distribution. In other words, BTI pinpointed as the root of the insolvency that this €135 million should have been used to fix the pollution problem, rather than distribute this to shareholders, and this would have meant that AWA would still have been solvent and trading commercially 9 years later and able to pay its creditors. BTI argued that this €135 million dividend by AWA directors to Sequana made AWA become insolvent, and it was therefore technically an illegal dividend distribution. BTI therefore sought to argue that this €135 million dividend was a transaction which was illegal, and which should be recovered. BTI therefore sued the directors for breach of company law in making this distribution of dividends which they stated was unlawful in breach of company law, and they also sought to sue Sequana under insolvency law to pay this €135 million back. In other words, BTI sought to get the directors and the shareholder, Sequana, to pay them this €135 million relying on company law and insolvency law. The former directors of AWA and their shareholder Sequana naturally put up a defense to this. These arguments between BTI against the directors and Sequana essentially came down to an expert accounting evidence. BTI argued that this distribution made AWA insolvent according to its expert accounting report, whereas Sequana and its 5 directors argued that it was not technically insolvent according to their expert accounting report, as Sequana and its directors argued that in the 9 years after this there were lots of things that could have been done to keep AWA trading. The court essentially accepted the evidence from the expert accountants representing Sequana and the former AWA directors, stating that after this €135 million dividend distribution AWA did not technically become insolvent as being more credible and reliable. The court found the arguments of the accounts explaining that during the 9 years after the E135M dividend distribution by the AWA directors to Sequana, AWA could have still have been run in such a way that it could have survived as a profitable organization, meaning that AWA was not technically insolvent after the dividend distribution. This €135 million dividend was therefore held not to have breached any company laws, nor did it trigger insolvency laws entitling it to be repaid. The court basically upheld this accounting report that this distribution did not make AWA insolvent, and so the liquidator, BTI, acting on behalf of the creditors was not entitled to get this €135 million back from the directors or the shareholder Sequana. The court did affirm that if the accounting evidence had stated that this distribution did technically make AWA insolvent at the time of this dividend, then it would have been arguable that the directors may have been made liable. And, in some extreme circumstances, a shareholder may have to repay a dividend if they knew it came from an insolvent company as well, but this case was not an example of one where this could be done. In short, if dividend distributions make a company clearly insolvent, it is possible that the directors may be made personally liable for these, and the shareholders who receive them may even have to pay them back if it is widely known that the organization was insolvent at the time of the distribution, but this particular AWA case was not an example of this actually taking place. In short, BTI lost, and Sequana and its 5 directors won. Sequana and the former AWA directors did not have to repay the €135 million shareholder dividend they distributed back to BTI and creditors who were owed money.